1943/2022.
What is that?
19043/2022.
Please verify whether the SLP is pending. Yes. The registry to verify whether SLP is pending as claimed by the party in person and to list the matter accordingly. Yes. 50.
My lords, I appear for the appellant, my lords.
Please find out if
My lord, the respondent had to file its objection.
Non-filing of objections to IA 1 of 2022 for stay. What is this about? 2022 appeal.
Please, my lord. My lords, we had challenged the show cause. There were several
This
irregularities.
was immediately after, if the
Please, madam.
objection is being filed in the
Please.
meanwhile.
There's
let it
interim
be.
order in 50 and 50.1.
Yes.
Both may be extended.
Yes. just
And the
after
counsel
completion.
for-
In the meanwhile, in case the respondent intends to file any objection to the IA for stay, the same shall be on record by then.
In 50.1, my lords, my name may be reflected.
Please.
Tushal. Any date, my lords?
28. 51, you Prasad.
The appellate pronounce. There was a direction to the response to file an affidavit.
I raise for some more time to file affidavit, my lord, because the matter is,
Yes.
my lord, your lordship may have it immediately after vacation, we'll file our affidavit. my lord.
Final chance.
Learned counsel for the appellant seeks time to place,
That's appellants in the connected matter.
yes, in
In
606.
606,
Please, ma'am.
The learned counsel appearing for the appellant in appeal 606 seeks time to place the affidavit on record list immediately after holidays.
please, oblige.
Sam at 1998.
Please.
52, my lord. We have already filed a report, but it has about 233 pages, my lord, wherein the copies of annexures which were produced by the petitioner and by the other respondents in the writ petitions are annexed. They're all Xerox copies of Xerox copies. So it is taking a little time, my lord, 232 pages typing and translation. My lord, it is already being done, my lord. I'm praying for time till 21st October, that would become 4 weeks. By then we will comply with the office objection, my lord.
Your lordship,
The office objection is with regard to translations.
Translation, clear, typed and translated copies of all annexures to be filed and copies to be served.
All annexures may not be required, whatever is relevant.
My lord,
to
some
this
of them are already a part of the writ petition. They had already submitted on the last date.
Those are not
Yes, my
required.
lord. I have sat and verified with the officer.
Only what is required you need to do.
My lord, some annexures which we produced in the comprehensive report are already typed and translated copies available in the writ petitions.
You need not. use
That
it
I am
for
not
reference.
that I am not typing.
Even the others, whatever is according to either of you, whatever is relevant, please make it available.
Because Yes, ma'am.
Otherwise, just simply spending time for translations is not required.
That
Because
also I shall communicate to the concerned, madam.
See that
But,
whatever is relevant is on record.
Lord, your lordship may kindly see the R sheet,
Hmm.
29/11/2022.
Hmm.
From then till now, they have taken sufficient time.
Only-
My lord,
only
one-
this.
One second, bear with me for 1 minute, my lord. I'll not take more than 1 minute. Now, my lord, this is fifth round of litigation by the government.
Hmm.
All 5 rounds, the government have suffered an order, and now, my lord, this is the fifth round also, my lord, the honorable learned single judge have observed. This is nothing but harassment to the petitioner anta heli, the fifth
What is the-
paragraph of the order of lordship.
What is the
will take-
subject matter?
My lord, regularization of the land in question, my lord.
Hmm.
My lord, first time regularization was done.
Hmm.
They have not issued Sagavali cheat. I approached this honorable court.
Hmm.
Mandamus was issued.
Hmm.
They didn't give Sagavali cheat.
Hmm.
Contempt filed. In contempt, Sagavali cheat issued.
Hmm.
Now, my lord, again, for revenue entries in my name, I filed a writ of mandamus for revenue entry. They didn't enter my name. I filed contempt.
What is the contention they're taking?
My lord, now what had happened is, my lord, in the meantime, my lord, without making the party, my lord, it was challenged before the Karnataka Appellate Tribunal also. There also we have one, the petitioner got a respondent got a favorable order. Now, my lord, again, without making the petitioner as a party before an assistant commissioner, a proceeding commenced for cancellation of this thing. He passed an order cancellation of the grant regularization made in my favor. That was called in question before the learned single judge. Learned single judge has taken note of all the previous round of litigation, including the order of the Karnataka Appellate Tribunal,
And
which has
directed-
attained, that has attained finality
And directed,
and directions.
and directed what?
My lord,
What did the learned single judge direct?
my lord, he has dismissed the order of the, he has set aside the order of the assistant commissioner.
Hmm.
Because revenue entries were standing in my name.
Hmm.
So therefore, my lord, the learned single judge have observed, it is nothing but a harassment to the petitioner by at the hands of the government.
Hmm.
And, he has been harassed, and the learned single judge observes that also in paragraph 5 of the judgment.
Yes.
Now, my lord, from past 1.5 years, because the pendency of this writ petition, this appeal, my lord, I am unable to enjoy because time and again the officers of the government will come and
Yes.
disturb my possession.
Time granted. Please take down the order. Time granted for production of the translated copies of relevant documents. The
607.
relevant documents shall be translated and made available before this court on the next date of hearing. List
Sorry,
immediately
my
after.
lord, there's some confusion. I was submitting for 53, my lord. My lord, 50, that is why I'm wondering, state is not an appellant. I got confused. My lord, in serial number 52, my lord,
Huh.
office objection is that division, regional commissioner is no longer a party. That had to be complied with, my lord. That office objection may kindly be overruled, my lord.
Yes. The
My lord, any date it may be called immediately after.
Just that are filed. I myself and my learned counsel on the other side, we have filed translated copies, barring only one document. This submission I made on the last occasion also, conditional order was passed. They're yet to file translated copies.
Yes, don't let us list it, let us overrule the office objection
Kindly,
and
my
list
lord.
it.
Kindly, I can
So
show
the-
from the records, any date may be fixed. with-
Your documents, you were,
Yes, I have filed all the relevant documents, I have filed translated copies.
is a requirement. Let's have it, let's overrule the office objections and see whether anything.
Or they can
the-
verify,
They can verify.
they can verify and make a submission the next date of hearing. Date may be fixed is my.
Courts have directed, my lord, whatever relevant documents we are also going to rely upon, only those actually instruct the office.
Yes, yes,
As of now, they are getting 234 documents.
absolutely not
translate.
required.
I shall also verify.
Most of the
But
records.
Some of the
The
documents. are-
original in vernacular is here.
My lord,
One of us knows the vernacular.
my lord, some of
This is a
the typed
difficulty.
copies and translated are available. That I have already segregated.
Important
Yes.
documents are in English.
Yes, yes.
That is already segregated by me, my lord. Only
Yes.
other documents are being typed.
Office objections are overruled for the time being, list immediately after holidays. On
Great,
that
sir.
day, please, if there is anything further that you wish to rely on, which copies have not been made available by the other side, only that.
Yes, ma'am.
Sir.
Yes,
21st October. ma'am.
21st October.
Great.
54, Vasant Fernandez.
Yes, copy served?
Copies are served, my lord, also sent to the party. Court notice to the party has also been served.
Hmm.
The thing is on 16/12, an order was passed by this court. On the same day, we took out process and a memo was filed by the counsel for first respondent seeking that he be permitted not to appear in the case. The thing is, he has not been appearing despite that, but the court therefore issued notice on the last date. That notice has been served according to the postal information. On 12/8/24, it has been served.
Notice issued to the respondent, Sri Amla Das, and is served but under.
Served and unreleased.
Served on 12/8/24.
Hmm. Yes, it is submitted that the notice to the first respondent has been duly served, but the respondent is unrepresented. But the said respondent is unrepresented before this court. List, now what is to be, what is the stage?
It's admitted and stayed, my lord, so it would be,
List on. Yes, the office objections therefore stand complied with. List immediately after holidays.
my lord.
55,
This
Nandakishore.
is a, last time it was under.
Appealing to the appellant, your lordship.
Final disposal.
Your lordships,
Our question is, under section 11A, if the proceedings are lapsed as on 1/1/2014,
Hmm.
that now the interpretation by the apex court is, it won't revive, it will not continue under 24(1)A. This is what exactly the facts of this case.
Hmm.
2010, the petition has been allowed with a direction to pass an award, and no award has been passed. And both of us filed a writ, both landlords and the APMC, they filed a writ appeal. Writ appeal was dismissed. SLP was dismissed. In the SLP, liberty was granted so far as my arguments are concerned. The provisions under section, under 2013 Act, if no award is passed, no compensation is there, that liberty was granted. Therefore, we filed a writ petition. The first is section 11 capital A millets. The award has not been passed. We filed a writ in 2017. 2020, when the matters were heard finally, they have come up with an award, that to a government order dated 7/1/2020, approving the award passed by the land acquisition officer. Land acquisition officer claims he passed an award in 2018 when the writ is pending. And government modifies it. In fact, your lordships are aware of it, that the Supreme Court said, so far as the land acquisition officer award is concerned, since he is an agent of the government, government has no power to modify the award passed by the land acquisition officer. And whatever the award passed by the land acquisition officer, the government modifies it and places an award order before this court. The learned single judge said, since 11A proceeding, when the writ of mandamus was issued, after the disposal of the writ appeal, there was no interim order pending before the SLP. Therefore, 11A was pressed into service. That's the position. Assuming but that millets, that 11A may not be applicable as per them. But in view of the judgment of the apex court reported in 2022, 2 SCC, page 772, paragraph 31, where it says, Malad, under the new act, award should have been passed within 1 year. That is 31/12/2014. The learned single judge, Malad, gives all alternative dates. Award was not passed within 2 years. Award is not passed within 1 year. Therefore, the proceedings get lapsed. That's the position.
For the appellants, Your Lordship.
Hmm.
Your Lordship, my senior's mother has passed away today morning at 10:30. So if Your Lordship could grant a short time, we'll appear, Your Lordship.
Yes.
Sorry,
Learned- Learned counsel for the appellant submits that there has been a bereavement in the family of the senior who was engaged to argue this matter. List immediately after holidays. Yes.
I'm sorry, I was not aware of it. Otherwise,
Much obliged, Your
time
Lordship.
it was understood for. This is a short question.
We'll
Please.
consider it on the next day.
Please.
Yes.
Much obliged, Your Lordship.
May I appeal to your lordship, some date may be given.
Okay.
Please.
56. Sindanur Vishwanath.
Steps taken, my lord.
Waiting service of notice.
Yes, steps. R1, please.
List it immediately after.
Please, my lord.
If a date may kindly be given, Your Honor.
Yes.
21/10.
Greatly.
57. Naveed Ahmed.
Last date of vacation, I had filed memo of calculation. They have filed an objections. They have served me a copy today. Get the instructions. The only thing is, we have given a deposit of 1,50,00,000. Only on that we have to discuss.
My lord, after giving deduction to the advance amount, my lord, according to them, my lord, they are liable to pay 37,88,984. But my lord, as per the agreement, my lord, is supposed to pay the rent as well as 18% of GST amount. My lord, GST amount has not been included in his memo of calculation. Then as per the agreement, my lord, the TDS has to be deducted. He has not given the certificate of deduction. So therefore, if all those things are complied, my lord, according to me, my lord, still liable to pay 2,04,46,000.
But TDS, if it is given,
Calculate-
GST is not calculated here.
Yes.
I'll just clarify with
Yes,
that.
please do. When?
After vacation. No vacation.
Next week can be done, tomorrow itself, this calculation. This is much,
Friday, we'll make an attempt. Friday.
7.
This week.
9. 58. Vaishali Srilakshmi.
You withdrawing? Yes. The learned counsel for the appellant has placed a memo on record seeking to withdraw the commercial appeal.
My lords, I don't have a copy of the memo.
I've not sought for any
I
liberty.
I hope they're not seeking any liberties.
I've not.
No.
Yes, the above you
No
have.
problem.
My lords, I don't
The-
have a copy also, but I will
We'll-
insist now.
Is dismissed as withdrawn.
That's all.
Nothing
that
else.
I- That's all that I've said.
I'm agree. 59. Against
Translated copies.
Yes, my lord, the relevant translations copies I have produced, my lord.
Yes.
It is a
the
selection matter.
Office objection is dispensed with. Yes, if there is anything that we require, we'll ask you.
I will do it.
Yeah,
I will do
so when will
Like-
we hear this?
It is a selection to the post of my lord police sub-inspector. Where my lord, my grievance is regarding my lord
Ready?
evaluation.
For consideration of interim ready.
My lord, notification.
Hmm.
My lord, dated.
Hmm.
21/1/2021, annexure A1.
21?
21/1/2021, annexure A1.
Hmm.
Where there is a prescription of my lord, written examinations consisting of my lord, 2 papers.
Hmm.
My lord, translated copy I have produced. My lord, at page 166, the relevant, my lord.
Hmm.
Where paper 1 is consisting of my lord, descriptive type, where which is in Kannada as well as in English. And paper 2, it is consisting of objective type questions, my lord.
Hmm.
Now, my grievance in this case is regarding,
Hmm.
my lord, the evaluation of the first paper 1, my lord, descriptive type answers,
Hmm.
where,
Hmm.
my lord, 19, their own circular, and the notification prescribes for, my lord, 2 evaluations
Hmm.
by the 2 examiners.
Hmm.
And if difference of marks is 15 is there,
Hmm.
refer to the 3rd examiner.
Hmm.
Your lordship may kindly see, my lord, page 167, translated copy of the notification, relevant extract,
160?
167, my lord.
Hmm.
Candidate can answer essay writing in part 1 in English or in Kannada. 2,
Just a moment, where is all this? 167.
167, my lord.
Can we-
Instructions,
yes.
instructions, I'm sorry,
Hmm.
I apologize.
That's all.
167,
Hmm.
instructions, my lord.
Hmm.
Candidate can answer essay writing in paper 1 in English or Kannada.
Hmm.
2, paper 1 answer sheets will be computerized and secondary and territory evaluated. A decision of the additional director of police recruitment chairman regarding the conduct of the said proceedings will be final. My lord, kindly say, my lord, in support of this, where, my lord, 2 elevation has been done at the first level. My lord, circular is dated 5/2/2019. My lord, translated copy I have produced at page number 372.
372.
372, my lord. In the bold column in the bottom, my lord,
Hmm.
I'll read it from paragraph 3, my lord.
Hmm.
For greater accuracy of the said evaluation process,
Hmm.
and to reduce the subjectivity as much as possible, and because this subjectivity should not inconvenience any candidate,
Hmm.
it has been decided to adopt the model of secondary and tertiary evaluation process adopted in the Karnataka Public Service Commission in the evaluation of the written examination paper 1 for the post of police sub-inspector. The Karnataka Public Service Commission manual as mentioned the following regarding the evaluation of the answer papers.
Hmm.
Each script shall be subjected to double or triple evaluation as may be necessary by 2 or /3 different examiners evaluators. If the difference of marks between at first and second evaluation is less than 15 of the total marks of a paper, then average of the total both valuation marks is taken as the marks secured by the candidate in that paper. If the difference of marks between first and second evaluation is more than 15, then such answer book share subject to 3rd evaluation. The case of the answer book subjected to the 3rd evaluation the average of the nearest total marks of the two evaluation marks shall be taken as the marks secured by the candidate. After third evaluation, if the difference between the marks awarded by the three examiners are found to be equal, then highest marks awarded by any of the two examiners shall be considered for the purpose of calculating average marks. Since the first stage evaluation process of the written paper, test papers, one for the post of police sub-inspector civil has already been conducted and completed, it has been decided to implement the second, third evaluation process for the reasons explained above and to follow the KPSC model. The
Just a moment, just a moment. This is a circular dated 5/2/2019.
19, it is last line, your lordship may see, my lord, it is adopted all subsequent examination. I'll read my last line. The evaluation process will be carried out accordingly. Also, it has been decided to conduct the evaluation of the answer sheets of the paper one of the written examinations for the recruitment of the post of police sub-inspector for all groups to be conducted henceforth as per the process prescribed above. 19 only, during the course of 19 examination, my lord, first time, my lord, the selection committee adopted this method, and adopting this method only, my lord, notification was issued in the year 2021, where, my lord, I read that page 167.
Yes, let us go right to the finding of the tribunal on
No,
this.
no, my lord, what they did is, my lord, in the first round of litigations, my lord, it is a second round of, this selection is, my lord, once, my lord, it is, round, it is came to the High Court had sent to the, my lord, to the fresh agency, where, my lord, earlier selection committee conducting the, my lord, dual evaluation. However, my lord, after the litigations, my lord, when the matter is entrusted to, my lord, KEA, as per the directions of the Honorable Court, my lord, now KEA, without taking any instructions, my lord, conducted only one evaluation, which resulted in, my lord, the marks, certain candidates got the higher marks, certain evaluations, my lord, and my lord, evaluated rigidly got lesser marks.
On perusal of the contentions by respondent number 2, Karnataka Examination Authority, it is revealed that the KEA has adopted valuation process by which two examiners have evaluated the answer scripts at first level, and then the answer scripts were reviewed by independent reviewer. This formula adopted by R2 seems to be without any bias. The applicants have not made out any case of mala fide or other irregularity in the process. From the documents on record, we are of the considered view that there is no irregularity. Therefore, as a matter of fact, tertiary evaluation has been conducted 1, 2, and 3.
No, they have not done like that, my lord. Kindly see the reply statement.
Yes.
Pager, reply statement.
No, this is the finding of the
Reply statement page, my lord. Kindly see, my lord, what they stated in the reply statement. Page 353, my lord, para 6. It is submitted that since the paper one consists of both English and Kannada language subjects, this respondent got the paper one evaluated by English and Kannada evaluators separately, and both of them have awarded separate marks. Thereafter, to achieve fairness in the process of evaluation, papers were referred for verification by two more verifiers who verified the correctness of the award of the marks by the evaluators and have signed a score sheet of the answer skips. This is not the method adopted, my lord, earlier recruitment and the previous round, my lord. It is exactly
that was only procedure which was adopted by the
fourth
authority.
respondent.
And
Fourth
therefore-
respondent.
Just a moment, please show us the judgment by which it was entrusted to KEA.
High Court judgment page number. My lord, it is 283. My lord, last writ petitions are dismissed. They ensure fair re-examination.
Just a moment.
I'm sorry. To ensure for fair re-examination, the state government shall entrust the process of re-examination to an independent,
Yes, from 45 onwards, the allegation that the recruitment being involved in the scam is the option exercised by the executive to cancel the examination to all. 283.
83, my lord, last line.
Hmm.
They, in the last line, they have entrusted it to they are directed to entrust it to the new agency, my lord.
Therefore, we hold that the order passed by the state government in the facts and circumstance of this case is just and appropriate and does not call for any interference. Accordingly, we answer the point in the negative. For reasons recorded here and above, we are at one with the view taken by the KSAT and therefore the impugned orders do not warrant any interference.
My submission is, my lord,
Next, to ensure fair re-examination, the state government shall entrust the process of re-examination to an independent agency without charging any fresh fee from the candidates. Therefore, the independent agency, which is entrusted with the conduct of the examination, is also free to devise its for the,
but
unless you can show
no notification, it is,
that the procedure adopted by the independent agency which was entrusted is
it is contrary to the
illegal.
notification. My submission is, it is contrary to the notification.
There is where in the notification does it
My
say?
lord, notifications of page 167, where, my lord, issued by the, my lord, earlier by the selection committee, my lord, in the year 2021, clearly says, paper 1 answer sheet will be computerized and secondary and tertiary evaluated. My lord, this particular part has not been done by the new agency, my lord. And the decision of the additional Director of General Police Recruitment Chairman regarding the conduct of the said process will be final. My lord, which I just read, that the earlier proceedings, my lord, were adopted, where they have decided to adopt the same method as method adopted by the KPS. My submission is, they evaluated Kannada one examiner, English one examiner, but the total the answers were not examined by the two evaluators. And my lord, 38
Reviewers also.
my lord,
2 reviewers as well.
earlier what they did is, my lord, entire answer sheets were, my lord, computerized and evaluated by the 2 experts, my lord. Without, my lord,
They have to be
influencing, my lord, the
secondary.
earlier,
They have to be secondary and tertiary evaluated. That is all the notification says.
that has not been done.
Anything else is some kind, and where did that leave you?
Only one evaluation is
Their
done, my lord.
examination was tainted.
My lord, only, my lord, kindly see, my lord.
Examination conducted in accordance with the notification was completely tainted by
Yes.
malpractice.
But notification is not
by-
changed.
Notification may not be changed. Only the notification remains. Nothing else remains.
My lord,
Because
tribunal, my lord.
whatever be the method adopted, everything was tainted in the earlier round.
but it is,
By malpractice in the examination itself. Which
that is
why
over,
this
my lord. I
court-
am not,
this
my
court
lord,
found it fit.
my submission is, my lord,
Hmm.
when the matter is entrusted to new agency,
Hmm.
my lord, they have to stick on to the notification because there is no other instructions issued by them. And the 2019 circular, they are not disputing. They are not stating that, my lord, we have followed this notification. They say we have adopted our own independent method of evaluation. That is impermissible.
Yes.
That is impermissible. Kindly see, my lord, tribunal. Tribunal. And they have not notified at all. They have not notified about the manner in which they are going to, my lord, evaluate. And 38,000, my lord, answer scripts were evaluated within 5 days by the single examiner.
Yes. We'll hear the response.
Lords, insofar as the notification is concerned, Lords, all that the notification says in Kannada, my Lords, originally, it says double or triple valuation. That is what we use. Nowhere we say, my Lords, that it will be triple or it will be double. We have said we are going to do a double evaluation. In Kannada, it says Ditya or / Tritiya, it says. It's a double evaluation or a triple evaluation. I can adopt either of the two. The proceedings that my learned friend is referring to, my Lords, has not been incorporated in the recruitment rules. So therefore, my Lords, my Lords, as per the recruitment rules, my Lords, recruitment is conducted by the recruitment cell, which is headed by the, my Lords, ADGP. Earlier examination, my Lords, the state found, once the provisional select list was issued, that there were malpractices, my Lords, on different counts, including Bluetooth malpractices and other malpractices. So therefore, state decided, in fact, the head of the recruitment cell. That is, the ADGP itself was the main accused there. So therefore, my lords, state took a decision to cancel the examination and order for a re-examination from the stage of the examination itself. That was challenged before the KAT by the persons who were in the provisional select list. Unsuccessfully, my lords, therefore matter came up before this honorable court. Before this honorable court, my lords, this honorable court said, my lords have seen the operative portion. For the sake of transparency, it is better that because it is not an independent agency. As per the rules itself, it is the recruitment cell of the department that was conducting this. So it should be entrusted to a third party agency. Now, when we entrusted to KEA, my lords, what KEA did, there are two papers. The issue here is only with regard to paper 1. Let's paper 1 here has, my lords, is a 50 marks paper. It is, you can answer it in either in Kannada or in English. Now, essay writing, one question is there. It can be answered either in Kannada or in English. Then, my lords, there is a translation paper, the translation question, where, my lords, that it has to be answered as a translation, which is from English to Kannada, a Kannada to English. So therefore, my lords, it has to be answered in English. The third question was a precise writing, which was in Kannada. So you have to make it a short form. So therefore, the answer script would contain both an English answer as well as a Kannada answer. What KEA did was, it got evaluated each paper by two persons, two evaluators. One a Kannada expert, one an English expert. So that it could, because the answer is in both mediums. So therefore, my lords, they even went to the extent of having one Kannada examiner, one English examiner, basically a person who is competent in both. And, my lords, they got it evaluated. The additional cross-checking is with regard to the marks. Each person, my lords, has cross-checked it. Now, tribunal, my lords, there are 3 applicants herein. If their grievance, my lords, is in fact that there has to be a third valuation. Third valuation, how it has to be, it has not been notified. Rules do not specify that. Some proceedings of 2019, which is just a proceedings of the ADGP, which has not been incorporated into the rules. So original answer scripts, my lords, were placed by the KEA before the court. It has been perused. Kindly see one finding, my lords, of the tribunal.
We have perused the documents, additional documents, judgments. So order process shall be entrusted to independent agency. Re-examination conduct.
Para 17 minutes, page 83.
Yes.
My lords have it, my lords. The learned counsel for the respondent to contends that there is no deviation in the pattern of question paper. The script has been examined by 2 different examiners, kindly noted, and evaluated. The same has been reviewed by independent reviewer, who after review has given marks. We have gone through the Xerox copy of the booklets of the 3 applicants made available by the respondent number 2. For paper 1, the questions and answers are in form of a single booklet. It consists of both English and Kannada language subjects. It has 50 marks, out of which 20 marks for essay writing, 10 for precise writing, and 10 for each for translation from Kannada to English and English to Kannada. Notes, I stand corrected. They're both translations. On perusal of the document, it reveals that the paper 1 is evaluated by both Kannada and English examiner, who have both signed along with their code. The same has been reviewed by 2 reviewers along with their code names and code numbers. The contention of the applicants that they were not aware of the evaluation process does not seem to be correct. As in the last page of the booklet, the method of evaluation, marks by examiner and reviewer is mentioned.
Oh, the booklet in which they answer.
Please, Milords.
We have made available to the court.
And not only that, Milords, if a recruitment notification specifically provided a detailed procedure, I was bound by that, Milords, in view of Bedanga Taluka, unless I deviate from that, or this honorable court issues may guideline. Now, Milords, all it said, the one single sentence says that the valuation shall be conducted by double or triple valuation. This is what it says, or triple. It does not say triple. How it has not, nowhere it has been specified, neither in the rules. They are relying upon one proceedings.
On perusal of the contentions by respondent number 2, KEA, it is revealed that Karnataka examination authority, the valuation process by which the examiners are the answer scripts at first level, then the answer scripts were reviewed by independent reviewer. This formula adopted by respondent number 2 seems to be without any bias. Applicants have not made out any case of mala fide or other irregularity from the documents on record. We are of the considerable. Yes.
My submission is the notification, this honorable court has remitted the matter to the directing to entrust the examination to the new agency. But contents of the notification has not been altered by either by the Honorable High Court or by the selecting authority.
Yes.
The earlier round of examinations from 2019, they have conducted examinations and with the 2 evaluations for Kannada as well as in English. Now what they did is only 1 evaluation for Kannada and 1 evaluation for English they did it. It is clearly, since the different examinations are going to evaluate the answer scripts, there is a heavy discrepancies in the marks awarded by the each examiners. Kindly see the Sanjay Singh's case of the FX court.
Just one clarification, my lords. Each paper was evaluated by both Kannada person and English person. I think
No,
the
no, my lord. Let them file that affidavit. They have not done that.
What has seen the
Kindly
papers,
say, my
my
lords, if they conduct,
Finding by the tribunal.
if they, my lord, conduct the, my lord, two evaluations for
Have
Kannada
you-
and English, my lord, I
Have
have
you
no case.
raised, any malafide acts against the tribunal?
My lord,
Yes, we'll consider. We-
okay,
we're
kindly
not
say, my lord,
inclined
para
to grant-
23.
We are not inclined to grant any interim order as of now. We'll hear you on the merits of the matter
Please.
immediately after.
Let him not publish at least the final select.
No,
my lord.
No, my lords.
This is sorted once, my
Pass any
lord.
interim.
Once it was already
Because, my lord,
sorted by them.
Yes.
Grateful.
Notice.
Doctor.
Notice, my lord.
Yes.
A short date may be good.
Takes notice. Yes.
Short date may be good.
Yes. Then list it only after. Then don't let it be listed every now and then. Yes.
Final hearing. Number 60, R. Chandrana.
The records are secured, madam, but they are totally in pieces, madam. The entire Darkhast register. So, my lord, I am told that in 2014, there was some scanned copies done in the office at that point of time. I will also verify from them, from the office, they will verify and get back to. This register is totally of no purpose, my lord.
We'll await the copies of the records. Records are
The
required.
certified copies were issued to them. If on that only they want to argue, they can go on with the matter.
Copies are produced and there are records. Earlier, the court has looked into these records and
Look at the state of the records. This is what.
All this exercise was once done.
Yes,
And what is contained in that, this thing is also noted in the order.
Therefore, it may not be required. The verification of the record.
By itself may not be
May not be.
this thing. Of course, if there are scanned copies, let them get it. If they are not,
Then we'll have this immediately after holidays. Anyway, today, hearing the matter may not be.
Because once in 2014, my lord, the deputy commissioner was present and they produced the records then. At that point of time. Thereafter, they say that they may be scanned. This is totally of no use, madam. There are all the documents, not only this particular Darkhast register, the entire register, madam. I'm not aware, 1937, 38 documents. Madam. So if they have scanned copies, I shall produce them on the next date, my lord, or I'll submit.
Yes. The learned government advocate submits that 21st records were called for. The state of the records is not conducive for an examination. As the records have disintegrated to a very bad extent. It is submitted that if scanned copies of the records are available, the same will be perused and necessary documents will be produced. Please, list after holidays.
today at page 205, when the records were earlier produced, the learned single judge has noted this is what is contained in the record.
That is so we can hear it even if the records are not, even if the scanned copies are not available, with what is on record, we'll
Because, my
consider.
lord, at that point of time, they have obtained certified copies. So that is,
Copies are absolutely.
they're already producing that. This is a matter which is restored back to file. My lord, the copy of the writ appeal is not available because it's a disposed of matter. I've requested the counsel for the appellant to serve a copy, my lord, so that it will be easy for me to argue on the next date. I shall take it, please, after vacation.
Please.
21. 21:10. 61 urgent, 62 government advocate.
My lord, in this matter, my lord, some reports are to be. Additional Advocate General, Mr. Santosh Gogi will be appearing in this matter, my lord. There is a direction to file a report, my lord, with respect to the daily wages. That is already ready is what my instructions are. Immediately after vacation, my lord, the learned Additional Advocate General will be present, my lord.
But my only concern is not been given because we have filed a contempt, our salaries have been stopped. Can we live without salaries?
Yes, what do you say?
My lord,
They were being paid their wages till now. On account of the fact that they filed a contempt, the wages should not stop. What was the direction?
My lord, any action in terms of the directions given in para 4, Group C and Group D, classifying persons in different categories and instructions on pay scales had to be given, my lord.
So whatever that be,
There was a,
it has to be, no, it is not as if they've been thrown out of service. So if it is true that it is on account of their having filed a contempt that their pay is stopped, it's a serious issue. Please
I shall-
instruct them appropriately that their pay has to be, it cannot be stopped on this account or whatever be the,
I understand, my lord. I shall also instruct the authorities, my lord. It may be called immediately after the reopening, my lord, and additional advocate general will be present, my lord.
shall we have this once before the
Please, my lord.
vacations, only for this purpose?
1st October, 30th or 1st October?
30th.
30th
30th
September.
30th September. Let
Please,
us
ma'am.
list it on 30th. Please see that the.
I shall
pay is
take
released.
instructions on this
Yes.
only aspect and
Yes, as to
submit.
why, for-
Wages are being paid
Yes.
or not?
yes.
My one more submission. All along we have been paid.
Correct, we understand.
Just only this month they have not been paid.
So unless there is some pressing reason,
I understand.
we will take that as contempt of the directions.
Only on that,
Yes, only on.
to reply only on that, whether
Only on the
wages
payment
of
of
this month have, why it's not been paid?
Yes. Learned government advocate seeks time to get instructions as to whether the petitioners before the learned single judge have been paid their wages for the current month, and if not, why? Please list on
Not all the petitioners, not all the respondents.
only
Some-
the contempt of court, only those who have filed the contempt.
No,
Some of them,
even, some of them has not been.
some of the
So
petitioners.
there should not be any incorrect submission from my side.
Some of the, it is submitted by the learned senior judge, the petitioners in CCC 1557 of 2019, that some of the petitioners have not been paid their wages for the current month without any justification. Learned government advocate to get instructions, list on 30th.
Much.
30th.
63, Hari Prasadian.
My lord, I appear for respondent number 1, my lord.
I Yes.
For the appellant in this case, my lord.
Yes.
Senior counsel is engaged, my lord. Kindly have it next week, my lord.
What is the matter about rectification?
It's not rectification, my lord. I have challenged the order of the learned single judge, wherein the
Yes.
learned single judge has granted civil relief in a writ petition. That I have challenged.
Can we have this immediately after the holidays?
Very well, my lord. I mean, I'm in your lordship's hands.
Yes, learned counsel for the appellant seeks a short accommodation, list immediately after holidays.
Please. Grateful.
64, G.S. Venkat Subrao.
AICT. AICT is not appearing. Yes, what is this for? Failure.
Finally.
Just after holidays.
65, Murugesh V. Charity.
Appear for the pleading applicant, or proposed respondent. There are 3 writ appeals connected. In the third matter, my lord, I appear for the appellant.
I am for the respondent.
I'm for the appellant in this case.
I am the
We are
original
engaged with
petitioner.
senior counsel. We are engaged with senior counsel.
Do you have any objection to the applications for impleadment?
I have filed objections on that.
You have filed.
Yes,
So the
because I am the original petitioner, I have succeeded.
Now,
But
what is the
impleading
contention?
Application may be also influences because also filed a writ appeal, saying that he had filed another writ petition where the same survey number was challenged, land acquisition was challenged. That also has come to be disposed of, but I just verified, my lords, there is a writ appeal filed, but there is continuation, delay also in the writ appeal. and there is a peremptory order to comply with the observation within 3 weeks. I don't know if it is complied or it is
Right,
dismissed,
it is
I'm not aware of.
That is so, then there is no need for this impleading. We
Pleading
just have to
application
list
may
it
be
along with,
considered on the next date, Manoj. There is no
Yes.
urgency on the consideration of the pleading application.
just after holidays.
I represent appellant
It
in,
will kindly be fixed, my lord. The
appellant
reason-
in writ appeal number 900 of 2021,
9?
900 of 2021, for 3.
Yes, yes.
The copy of has not been furnished to me. Actually,
It's responded.
Copy of,
the writ appeal filed by the impleading applicant.
If
that
it is
is-
not served, I will serve, my lord. That's not an
Notice has
issue.
not been ordered in that matter.
It is, it is. I have
Listed-
served the copies to all.
It has not been served on me. I am the original owner of the land. The BDA has acquired from me and the compensation is received by me.
yes,
So the two people are challenging that ownership.
yes.
That
list-
is in respect
Yes.
of one survey number. I am
List
fighting
after
for 8
holidays.
survey numbers.
Copy has to be served on me.
In the meanwhile, please serve copies.
Sure.
Yes. list
May I
after-
request, my lord, to kindly fix a date, my lord, 28.
Shorter.
28th of,
Earlier application was also filed by them.
A shorter date, Manoj, because
22nd,
Very well.
because court officer is giving dates on Mondays. So that normally there is a chance that it will be taken up. That is the attempt, because on that day, the service matters will not be there.
Oh,
That was the intention. We'll have it on 22nd. We don't know whether it will be taken up.
one submission besides the merits of the matter. There's a 2023 matter connected that filed by the writ appeal. But as far as I verify, 2020, the senior judge having roasted 2020 is the next court.
Let it go before it is- let everything go before it is.
So I'm just submitting minutes because
Well, they absolutely
tomorrow,
not.
based on roster, nobody should challenge.
no, that will not
I
happen
don't know what the
anyway.
next roster
We
will
are
be.
only too happy.
I don't know what the next roster will be, I'm just submitting this anomaly.
We'll see, according to the next roster, it will come.
Wherever
Don't
it
worry.
comes, my lord, we are having pleasures to argue.
Yes,
But date may be.
22nd.
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 Great.
Room orders, if any, will remain in force.
66, Mitchell Pradeep Kumar.
For the respondent.
Yes,
My lords, senior counsel is engaged for the appellants. Some short accommodation, my lords, he's on his legs. Any day convenient, my lord.
yes, so we'll have to have it immediately after
Please.
the vacations. What is this about?
My lord, I am the owner of a piece of land. The KDB acquired it. I surrendered my land on condition that half the land will be given to me as developed land. There was a scheme also according to it. They gave me the land, but they put conditions to say, like all other allotments, you must construct, you must do this, you must do that. And then they say, you've not done that, therefore we're taking back the land. So neither I have the land, nor I have the developed land, nor I have the compensation. The learned
The
judge
allowed
has
writ
allowed the
petitions
writ
are in.
petition.
Yes, we'll have it immediately after all.
Please, my lords.
Yes, please give a date.
28. 67, Kashinath Reddy.
My lords, interim order may be extended.
Yes, interim order shall remain in force till next date.
67, Kashinath Reddy.
Here for respondent.
Yes, who appears for the appellant?
Mr. Kashin.
It's like everything is collapsing. We were under the impression we wouldn't be able to even rush through the listed. Everything is gone for a 6. It's all right, this last week before. After vacation?
68, Jaikar Shetty Hai.
Any case where both sides are ready? Yes,
69, Sarvantari Tandra.
Time for the appellant, some inconvenience with senior man. Immediate,
yes. So therefore we can hear you. Can we not?
not ready with the matter.
How old are you at the bar?
1 year.
More than enough. You can make an attempt.
Definitely, my lords, but just with the matter.
We'll assure you that we won't pass any adverse orders.
One of the easiest subjects which is being given to him actually to us. PTCL Act is very easy, settled in laws.
Why don't you make an attempt?
My lord's on the next date, man. I'll be ready with the file on the next date.
Yes. We'll take you up on that.
Please, my lords. Interim order may be extended.
Yes.
30th. 30th.
That's right.
ಅವತ್ತು ಈ ಮಂತ್ ಅಲ್ಲಿ ರೀಚ್ ಆಗಲ್ಲ, ಇವತ್ತು ರೀಚ್ ಆಗಿದೆ ಅಷ್ಟೇ. After vacation.
Yes. On that date, you will be ready.
Please, my lords. Interim order may be extended.
70, Prasanna Kumar P.
69, you're ready?
Yeah, I'm ready.
Can we take it up?
I am for respondent, madam.
Ah. So then, we'll have to list it after vacation.
Any next week, my lord?
Man assures me that he'll argue the matter next day. We'll have to wait for him to get ready.
Please, ma'am. Next week, my lord? A date may kindly,
Next week may not be possible.
please,
And
after
if we
vacation.
listed it, may
After
not be
vacation.
possible.
When date may kindly be granted.
Yes.
After vacation, my lord.
28th,
In ಸ್ವಲ್ಪ ಮುಂಚೆ.
21st.
Please, my lord.
Yes.
November first week, my lord.
14th.
First week of November.
November 1st.
October, the calendar is full, my lord. I apologize.
4th November. Calendar is full for the senior.
You are doing the arguing next time.
It's a lot of trial court, madam. Apologies, madam. So great.
Sorry, my lord, in the lighter vein.
Please, my lord.
Yes.
70, Prasanna Kumar P.
Ethical matters, I appear on behalf of the appellant, my lords. The on-record counsel, she's on her legs, my lords. In the connected matters.
What is the matter about?
My lords, this is the matter where we are challenging only with respect to the prayer B of the order passed by the learned single judge, my lords, where only with respect to the authority who has to initiate the inquiry proceedings, my lords, whether it is MD or that of the superintendent engineer of KPTC, my lords. Since it's an institution matter, my lords, the on-record counsel is not there, my lords. Pleadings are completed on the both ends, my lords.
Notice is served on all the private respondents?
Please, my lords, I appear on behalf of the appellant with respect to the appeals which I appear, my lords, has been served, my lords.
IA 3 of 22 is there, for bringing, is R2 on record.
These are two. Which is that?
70.4. IA.
70.4, my lord. To bring
Yes.
LRs on record, that can be allowed.
It's already there. That can be allowed.
Notice has to be issued.
Notice is not ordered with respect to. So that IA.
Issue notice, issue notice. Which are the matters where you appear?
My lords, serial number 70.1, 70.2, 70.3, 70.4, and 70.5, my lords.
70.4, please take
Please,
up
my
notice.
lords, I'll do the needful.
71,
Grateful, my lord.
acquiesce.
Nobody expected this to reach. Hmm.
72,
My lord, in 72,
Yes.
I appear for the. I apologize, my lord. Even I did not gauge the time right, and I'm on my way to court, my lord. But I appear for the respondent, please, my lord. This is that case where the question of partnership being registered or not was raised, if my lord recollects.
Is this
Commercial.
what you call a mobile court?
No, my lord. I sincerely apologize, my lord. I thought 4 o'clock I should reach High Court, but I apologize.
What of it? Yes.
My lord, any short date, my lord, because in this, the appellant is enjoying equivalent to that of a interim order without even order of any deposit, my lord, because I had undertaken not to precipitate, because my lord was of the opinion that it's a small point, and I sincerely apologize. Deeply obliged, my lord.
Apologies, my lord, I couldn't be here. But the AACT, my lord,
Item 64, ASCT, yes, please state that.
apologies, my lord, I can't be here.
Who appears against you?
The institute is, my lord, unrepresented, that's the problem.
Served and
Third
unrepresented.
and unrepresented.
What is the matter about?
My lord, AACT, my lord, at a relevant point of time.
Hmm.
That was the authority which was required to approve, my lord, the admissions and
Hmm.
reports.
Hmm.
Subsequently, by virtue of another ruling of the Honorable Apex Court,
Hmm.
but since it is no longer a technical course, my lord, Apex Court. holds
What
that,
is the course in question?
Pharmacy education.
Okay.
But, the Apex Court.
No, it is the Pharmacy Council which has to.
Pharmacy
approve.
Council of India.
Hmm.
Therefore, at the relevant point of time, my lord, they did require our, my lord, approval.
Hmm.
Now that, my lord, the change of proposition of law, I have written to AACT to.
Is it your contention that they have neither your approval nor the approval of the Pharmacy Council?
At that relevant year, my lord, we had not approved. My lord, they were before this honorable. court.
Later, it was approved by the Pharmacy Council.
Yes,
That's
my
the situation.
lord. That's, my lord, they'll have to, my lord, say before the court, which they did not say. My lord, that relevant year, my lord, we did not approve. Therefore, I have written to, my lord, AACT to clarify on this aspect, whether the appeal itself should be proceeded with or not.
Correct.
But, if the institution were to be here, my lord, it would have been, they would have, given much material before the court. Which,
Yes, can you, have you served on the council who appeared?
No,
Before the
through
learned single
court,
judge.
my lord, it is third year. Through the court, my lord, in the writ appeal, there was.
Through the court?
Please. So the writ appeal being admitted, my lord, the notice
Just a
was
moment,
served
just a
upon.
moment. Please, let's see what is suitable. Has it been served on the council also?
May hold or.
You do have a case in
Please.
paragraph 25 of the appeal
Please.
that the Pharmacy Council also has not approved.
I had not, as of then, it was not. In fact, my lord, we did have a discussion with AACT also, but if they had, my lord, otherwise taken admission, but if it is subsequently held to be, my lord, not in accordance with law, those admissions also will get affected. Unfortunately, institution is not before the court, my lord, despite being served.
Petitions. Grievance of the petitioners that the respondents point out certain deficiency based on. In terms of circular dated 7/6/2019, extending the time for approval with certain conditions and fulfilling the said conditions prescribed, petitioners are entitled to consider the representation of the petitioner in terms of the circular dated 7/6/2019 and grant letter of approval for starting the course from the academic year 1920. Compliance of this order shall be made and a decision shall be taken by the AICT in an expedient manner, not later than 2 weeks. 7/6/2019 circular says what?
Page 92, my lord, annexure.
92. Reference to Supreme Court
Honorable
order
Apex
dated
Court order.
6/2019 and so on. So Parshwanath Charitable
Parsh-
Trust versus AICT. In view of large number of new pharmacy institute applications, non-feasibility by PC in few cases appeal was made. In view of the above, No common decision by PCI and AICTE or considered for LOA. Provided you submit an affidavit mentioning that the institute is willing to run the pharmacy program approved by PCI
Yes.
from current academic year 2019-20 and shall
Shall fulfill APH norms and procedures laid down by AICT and APH 2019-20 before start of next academic year 20.
Is it your specific case that they did not have PCI approval?
No, my lord, they did not have PC approval, nor my lord AICT. Now, my lord, as of now, my lord, they do not require AICT approval.
Correct.
But nevertheless, they do, my lord, require PC approval.
What does the judgment of the apex court say?
But,
Norms and
the,
regulations of specified authorities and the Pharmacy Act would have to be followed by the institutions concerned. Imparting education for degrees and diplomas in pharmacy. Yes, please inform us whether you want to pursue this matter.
Please,
Because apparently those students who have undergone the also, who will be awarding the degrees now?
that may
Those-
PCI only. PCI, my lord, through the.
Therefore,
institute.
if they don't have PCI approval, the PCI probably would not issue the certificate,
Please,
permit
please,
visa.
please.
Probably, let us assume that they did have PCI approval because PCI is also not a party.
Not a, it was not a party in the writ, my lord. If that particular academic year, my lord, if my lord, they
Correct.
didn't have the approval, supposing they have, my lord, taken admissions and students have passed on, the court holds that, my lord, they did not approval. My lord, my lord, the interest of the students, my lord, will be in jeopardy. Which, my lord, the institution ought to have taken care, my lord, unfortunately, they are not there before the court.
Is the state a party here?
Yeah, but no, state is.
Otherwise, at least
State
the
is
state
not
could have made some kind of a,
State is not a party.
gotten some instructions as to whether they are still in operation, whether those.
There may be a direction to the jurisdiction. Generally, what has been done all these cases in other matters. They go serve a copy of the notice once again on these respondents and the respondents do not appear. Because process notice is served only through them. Goes to RPA, goes to RPA. If there will be a personal service of notice, other criminal matters and other civil matters also, generally court directs the jurisdiction. Copy of this notice is handed over to the jurisdictional police. They serve upon the court.
Just one more thing. Does the PCI have a standing counsel in the High Court?
Yes, madam. Here they have, they do have.
Can you please
Inform, my lord.
inform the
Please.
PCI standing counsel also?
Please.
And give a copy. If as a matter of fact, they did have PCI approval,
Please.
then we need not further proceed in the matter. It's
Please.
only if they did not have PCI approval also in that current year, then the issue arises.
But
Because
if-
we need not now, if as a matter of fact, they had PCI approval in the relevant year, and then they had admitted students on the basis of the PCI approval in the light of the judgment, maybe it may not be necessary to
Please.
further consider the
Please.
matter.
Another predicament for me to withdraw the appeal is,
Hmm.
my lord, the learned single judge's order will be still staring at.
Correct.
So therefore,
No, you don't have to withdraw the
Please,
appeal.
correct.
If as a matter of fact, they did have, then we can say that in the light of the judgment.
it
and
is not, I'm grateful.
For your approval may
Please,
not be
please.
required, that we can say.
Rightly, so, please.
So that the students will not
That's,
be,
that's the concern.
unsuspecting students will not be.
Yes,
put
that's
to
the
the-
concern, brother. Which
Yes.
institution ought to have been bothered, my lord, they did not, my lord, appear before.
In fact, the students would not even be aware of
They
this.
would not be aware. They would be absolutely unaware.
No, they are unaware.
Even in cases where there are cases, I mean, orders, students are unaware. Here is a case where they probably would be blissfully unaware. They
Please.
would have passed out also.
Yes, ma'am.
Yes,
5 years.
5 years
the-
down.
So please,
I'll have the council
let's see
informed.
whether the standing council
Please.
can help you in the matter. If as a matter of fact, they had PCI approval, let's
Please. Grateful.
turn it, council for the appellant seeks time to get instructions whether anything survives in the appeal list after all.
Grateful.
Please.
My apologies, my lord, I could not be here when the case was called up.
So you want it on the 30th or immediately after all?
Soon after vacation, my lord, take some time, I'll write down.
The standing council may also need to make the communications.
Please,
right now.
that's the reason.
Properly, sir. My Yes, that is the height of responsibility. In spite of notice being
Good,
served,
yes.
coming in a matter like this.
In education institution below that. What? Great.